welcome to the Hodlcast. Today is September 3rd. Thanks for tuning in. We're going to be going over the Celsius hearing that took place yesterday in the United States Southern District of New York Bankruptcy Court. The court received over 800 Zoom requests for people wanting to attend the hearing, and it was a little bit refreshing that all the lawyers, both Celsius's lawyers and the lawyers representing the various creditors, seem to have made a lot of progress on agreeing on certain issues and being able to tell the judge, hey, we've come to this agreement without needing the judge to actually rule on certain things. So Celsius stated that they've made some progress toward getting more money back, some good path forward with their recent lawsuits against a former employee, Jason Stone, and against Prime Trust, which in my last podcast, I was a little critical again about that Prime Trust lawsuit. It seems to me like something that could be resolved without needing to file a lawsuit, but that's neither here nor there today. The main thing that came out of the hearing was that the distinction between the earn and borrow program and the custody program has been set. The funds in the custody program are not considered part of the bankruptcy estate. However, the earn and borrow program funds are considered part of the estate. So Celsius has full title to the earn and borrow and zero title to the custody assets. This was a welcome admission by Celsius. However, now they're trying to divide those assets into three tranches. 48 million, they say, are pure custody, and those assets will be returned. The other there's 160 million that apparently were transferred from the earn program over to the custody program too late. They were transferred within the last 90 days of the bankruptcy hearing, and Celsius is attempting to make a claim that they can claw those back because they were transferred too late. There's 11 million that are valued. The transfers were less than 7,575. So there's tens of thousands of people in that boat that deposited less money than that preference cutoff. So the people that were either too small or too late, they're not going to get their money back right away, or the judge is going to hear that issue on October 6th. But the 48 million that were considered pure earn customers from day one, they will hopefully get their money back. It's looking like they're going to. The attorney for the Celsius creditors, Kyle Ortiz, he said that this conclusion was certainly a welcome relief, but Celsius needs to return all of this property immediately. It's not their property, and they're not at liberty to decide what to do with it. They need to return it, and holding it could be a violation of due process. Deb Kovsky, an attorney representing a group of holders, pointed out that the coins are illegally held by Celsius. There's cease and desist orders in a number of states saying that Celsius is not a qualified custodian and Celsius should not be holding these assets. Another attorney, Greg Pesk, representing another group of creditors, stated it's important to make sure that insiders like Mashinsky and his wife are not paid out through this custody account. So the names of the payout or the payees, they really need to be disclosed. Herman, an attorney representing a different group of creditors, stated that the earn program represents unaccredited investors who invested more than they could afford to lose with their deposit. So while Celsius changed their terms of service after the initial investments, depositors should have been notified that the investment wasn't suitable and they should have had their money returned at that time. So he's making a claim that the earn product should also not be part of the bankruptcy estate. Judge Glenn said the parties should confer and try and work these issues out on their own as best as possible and come back on October 6th for a final verdict. The second issue was the appointment of the independent examiner. So this is the Department of Justice. The U.S. trustee, the bankruptcy trustee, she requested after the last hearing, she made a motion that an independent Department of Justice examiner be brought in. And this happens, as we've discussed, when there's mismanagement, when it looks like there's fraud involved or mismanagement, then the Department of Justice needs to get involved. But the official creditors committee, they've submitted over 250 due diligence requests, and Celsius has responded to 160 of them since the last hearing. So everyone's been really busy, and the attorney for the official creditors pointed out that Celsius has been extremely responsive. Nobody seems to want this independent examiner. The official creditors committee urged the judge judge and the trustee to withdraw that motion for the independent examiner because they said it will take too long and it will stall everything having another examination, and it would be duplicative of the work that the official creditors committee has been undertaking, and it will cost, extra money. Not that the fee of the examiner comes out of the bankruptcy estate, but the cost of all the responses to the examination will use the time of lawyers. So that's what the expense comes from. Judge Glenn stated if an examiner is appointed, there will need to be a strict protocol for information sharing. So there'll be as little duplication as possible. And then the next issue is the privacy of the creditor names. So Celsius is claiming there will be significant harm if the information about its creditors are published. They cited cybersecurity or physical safety risks for the US creditors, and also GDPR violations for the EU creditors. There was a lot of back and forth on this topic. A lot of people gave opinions. No one, not the creditors nor the Celsius, seemed to want to publish everyone's information, like their full address, email address, and name. Everyone agreed that that opens people up to security and cybersecurity risks, but the bankruptcy law is such that you can't have anonymous creditors being part of a bankruptcy payout. So the judge stated something will be need to put in place where either the names are published and the addresses and email addresses are redacted, or everything is made available to interested parties. For example, Layla Milligan, the Attorney General for Texas, she was on the call and she spoke up at this time and said, we certainly as regulators have an interest in who the creditors are. I sound like the states might be bringing additional action, or they're interested, and the judge said, we certainly respect your interest here and we'll make sure that this information is easily available to interested parties, but they might have to make a motion and ask for it from the judge. It didn't get resolved. That got pushed to be resolved at the next hearing. And then there is the issue of the de minimis assets. So last time at the last hearing, Celsius, sprung on everyone that they were doing some de minimis asset sales, which, is usually like office furniture, and everyone was surprised to learn it was actually pretty large sales that amounted to multi-millions of dollars. It was things like stocks or bonds or equity interest in other companies. So that got resolved without between the attorneys. So they decided that anything under 300,000, the U.S. trustee will get a notice of the sale, and anything between 300,000 and 4 million will be added to the docket, and any party can object to the sale if they have an objection. It'll be public. And then the next issue was that the debtors were exploring the sale of GK8 business, and the official creditors committee was reserving the rights to, so basically they objected to that sale, saying we want to see what the bidding procedure is. We want to oversee this, any like major sales of assets or companies. And that was agreed to. So now the bidding process is clearly outlined and both parties agreed to it, both attorneys for the official creditors and for Celsius. And then there was a cash management motion. So the coin report needed to be updated. There was 61 million loan that was listed in a stable coin receivable, and it was actually USD receivable. So there was some confusion around this at the hearing where the attorney for the creditors made it sound like Celsius just pulled 70 million, out of thin air. And then Celsius attorney said, no, that's not what happened. It was 61 million and it's a conversion of a stable coin. It's not something that we pulled out of thin air, And the judge said, well, I'm glad you have 61 million extra dollars to add to the financials, but it does point to a little bit of mismanagement not having that labeled properly. And then we heard from Daniel Frischberg, who is an unaccredited investor that was invested in the EARN program. He represented himself. He was a young guy, very well spoken, and I really felt for him. I thought he did a great job with what he said. He asserted that his assets were stolen by Celsius. It was fraud, that Celsius encouraged him to deposit his money, claiming they were not insolvent when really they were, and they knew they were. He also alleged that Mashinsky and other insiders sold their personal Celsius tokens and bought them with depositors' money through the company, which was a breach of their fiduciary duty to the EARN holders or the EARN purchasers, and also embezzlement. And then there was a wage motion too. So all the debtors, Celsius, they sought to pay the non-insider severance awards. So several people were fired and got severance awards, and the severance amount got capped. So one woman in the UK, she was promised 48,000 as a severance, and everyone got capped at 7,000. So she's suing separately. I guess she's got some health issues and she wants her money sooner. And Celsius is trying to accommodate that. And the bankruptcy proceedings are saying, no, no one can get any special preference here. So more information needs to come, but it doesn't look like they're going to get it paid out early. And that was it. The next hearing there's one on September 14th and a big one on October 6th. So stay tuned. Have a great one. Thank you.